Slip and fall cases are a little bit harder, a little bit more complicated than most people are expecting. One of the reasons is because cases like this, the insurance company and even the law really expects detailed proof of the liability aspect of the injury, which means there has to be a lot of proof about how you fell in order to have a claim. Now, there are certain things you have to prove after a slip and fall. One is that you have to prove that there was a dangerous condition on the property, and you have to prove that the dangerous condition on the property was something that injured you. But in addition, you have to prove that it wasn't warned and that the owner knew about it or should have known about it. And this is what we call notice. Now, all of these different aspects of liability have to be demonstrated with proof, whether it's testimony, video footage, witness statements, or circumstantial evidence. If there can't be proof about liability, then it doesn't matter how injured you were because you have to have liability before your damages are taken into consideration. So while you're very injured after a slip and fall, a lot of times we have to dwell on these other aspects of the case, and that's why they're a little bit more complicated than most people think. It's not that you just fell on someone else's property and then you can write them a letter or file a lawsuit and win. You have to have your ducks in a row. So if you've slipped and fell, make sure that you can document the injury. Make sure you document where it happened, who you talked to, and what the accident area looks like. So that way you can bring a successful claim for a slip and fall.